With that, commissioners, let us move to our next item. So item 2B, I believe. Let's see. Okay, item 2B on the agenda. First, Mr. Sheets, I want to thank you for serving as outside counsel on that hearing. Is he already gone? That is fine. I thank him in spirit. So item 2B on the agenda, let me read it real quick. We're moving to complaints filed by Mark Littlefield against Ellen Wood, Had Enough Austin PAC, and Ellen Wood Fight for Austin, which allege violations of Code 2-2-3, conforming with the election code, and Section 2-2-32, reporting of direct campaign expenditures. Mr. Littlefield, you heard the procedures in the last hearing, and Mr. O'Toole, it seemed like you were on the call to hear those procedures. If you would like, I'm happy to do a speed read of those rules again. But
no, I heard them. It's not necessary to repeat. Thank you.
Okay. Well, in that case, 10 minutes apiece. Secretary Gober is our world-renowned timekeeper. So I will, as soon as he is ready to go in setting the clock so you can see it, I'm going to kick it to the complainant for their 10 minutes, and then we will go to the respondent for their 10 minutes for questions.
I'll start when they start speaking. I drank my water can, so it's not heavy enough to hold my phone, but I will find something to prop it up in the meantime.
Okay, fair enough. Then, Mr. Littlefield, whenever you are ready to start, we'll start the 10 minutes and we'll get a prop to see the clock. So go for it.
Okay. Thank you, commissioners. My name is Mark Littlefield. This is about 4 complaints that were filed. I have written a letter to Miss Ellen Wood apologizing for one of the complaints. And I think you've heard me before is that, a lot of times, on small circulars, there's no reason to file a complaint because, mistakes are made all the time. And I made a mistake on this one where I copied and pasted and I pasted her name above a complaint that was for a different PAC. And so I sent her a letter apologizing to that. And I probably should have copied the commissioner saying, I apologize for the oversight and that was my fault. So on one of them, that was it. On the others, again, these are about following reports on time and ATX1 reports. And I think that what you might hear from the respondent is that these rules are complicated and that because I found out that these errors were made, that, that the data and the information is out there to begin with. So no harm, no foul. And again, it's that you have the same types of donors and same types of PACs that are filed in our campaign at the city of Austin, and we end up here every 2 years, where folks think that it's that these extra reporting requirements that we require are not required of them, or that they are burdensome or ridiculous, or they're too difficult. And here we are again. If the commission were to decide that these complaints were worthy of a final hearing, I would bring to the commission the 30-day report, the expenditures that were listed on those reports, and the failure to list them on the ATX1 reports in a timely manner. And then finally, we have another one. The last one, of course, is a $25,000 contribution from a corporation, Continental Automotive Group. This is a corporate contribution. per city code, this type of contribution is not permitted. I think we need to I'm bringing this to the Ethics Commission, I suppose, because I think that we need to officially, the Ethics Commission, I guess, is a place to start the process to tell the city council, well, I guess we need to amend city code because this is not against city law anymore. The city code says it is against the law to accept corporate contributions, but it is not according to state law. I filed this complaint because literally the day I filed it, I thought that it was still a violation, and then an hour after I filed it, someone told me no, it's not anymore. And I said, well, we need to tell everybody that that's not the rule anymore. And so y'all are gonna make a ruling today, and it's gonna be dismissed. And I'm gonna take that and I'm gonna send it to everyone at council. I'm going, hey, we need to tell everybody that you can now take corporate money and these PACs. And that's a different day for Austin campaigns, that we can now do this. And it's no one's fault here in this meeting or down the road. That is what it is. Anyway, if you guys decide that there is a final hearing on these last two complaints, then I will bring the evidence about the ATX1 reports and the 30-day out campaign finance reports from Had Enough Austin PAC. And that is all I have to say. Thank you.
Thank you very much, Mr. Littlefield. Mr. O'Toole, as counsel for respondent, I will let Secretary Gober reset the clock. And whenever you are ready, sir, you may begin for your 10 minutes.
Thank you, Mr. Chairman, and all the members of the commission. What I'd first like to do, if I may, my name is Brian O'Toole, and I'm an Austin attorney for many, many years. First thing I'd like to do, so I don't waste time addressing matters that apparently are no longer an issue, can we get clarification of which of the four complaints that Mr. Littlefield appears to have dropped, but I wasn't entirely clear on it.
Sure. Secretary Gober, if we can pause the clock, I think that's fair. So Mr. Littlefield, if you want to clarify, I'm just going to ask if it is the complaint that sort of implies or says that Ms. Ellen Wood is associated with the, oh goodness, where was it? I had it right in front of me. The Fight for Austin PAC, is that the complaint that you are referring to, is the one that you apologized for?
Correct.
Okay, so that's not something you want to allege anymore. Got it. Okay.
Correct.
Fair clarification, which one you were referring to. That is what he was referring to. I will let Secretary Gober restart the clock, and you can go for your 10 minutes to.
Wasn't there one more? The one with the corporate contribution?
I will let the corporate contribution. I'll let the commission handle the corporate contribution one on their end.
Sure. Appreciate that. So, Mr. O'Toole, you have 10 minutes, and I'll let you get started.
Thank you. Well, I'll start with the corporate contribution, if that's still a live issue. And simply speaking, it just doesn't state a violation. As the commission well knows, it's the complainant's burden to specify what he believes, what he or she or it, whoever the complainant is, believes has been violated. The section of code cited to have been violated by a corporate contribution is section 2.2-2-3, which by my reading of it essentially just incorporates some kind of consistency with the Texas Elections Code. That there really is no way to tell. And even though Mr. Littlefield claims that it somehow is still prevented by code or prohibited by code, and that somehow perhaps the code section is unlawful, it's not clear at all what section he's talking about. The simple fact is that this does not state a violation, that there are no reasonable grounds to believe that this complaint, as stated, presents any kind of reasonable basis to believe a violation may have occurred. It's simply not there. I would further point out that even if there was more clarity, if there was at least some textual basis for the complaint, that it would largely be overridden by the United States Supreme Court decision in Citizens United. So I couldn't tell if that's where Mr. Littlefield was indirectly going, but that is the first complaint, and had enough Austin and Ellen Wood, my clients, believe that there's no grounds to proceed on that one. There should be no preliminary hearing on that matter. The remaining complaints are essentially the same thing. They say that basically ATX1 reports should have been filed by certain dates, and they weren't. What is undisputed is that the complainant had the information that he complains was not disclosed on the proper form, because he specifically references it. It was, as we explained in our written response, it was reported on a different form. This was a new PAC. It, I believe, submitted the paperwork to even be formed on October 2nd, which was a Friday. That paperwork was acknowledged by the city clerk on Monday, and then reports were filed that same week. Well, what they tried to do was figure out what to file. So you can get on the commission website, or the city website, excuse me, and you can see a reference to an ATX1. But there isn't any way to link from that page to determine how to fill out an electronic form that's called ATX1. So in a full effort to comply with the reporting obligations, my clients filed a 30-day report with all of the information disclosed on that report. And so one thing that I did as an attorney, and I noticed from listening to Ms. Davidson's talk, which I thought was very well done, some people spend an awful lot of time in this arena, the ethics and reporting legal obligations. I typically don't do that. I'm a commercial lawyer and follow the same pattern on every case. You figure out what the law is, you figure out what the applicable statutes are, and you apply the facts to it. So step one here was to go to the code and try to figure out, is there any requirement in the code anywhere that my client even file an ATX1? You can get on the searchable database of code sections and type in ATX1 and get no results. It simply is not a code violation not to file that particular form. Now, subsequently, the clients have learned how to file the ATX1 electronically. That there's no issue. They have filed many of them since that time. But importantly, as it is here with respect to the complaint that an ATX1 report was not filed, the information is on file with the city. It was timely filed, all of it. It was simply filed on a 30-day report instead of an ATX1 report. And that really is the premise of two of the remaining three complaints. One is that a certain expenditure was not disclosed on an ATX1. Another one is that certain expenditures were not disclosed on a 30-day form. And it really is an argument that purely champions form over substance. There is no question that the substance was provided. It's all in the record, and this is in our written submittal if any of the commissioners have not had access to that yet. But it was all on file. It's right there. It appeared it sounded from Mr. Littlefield's comments that he was attributing something of a dismissive attitude towards this to my clients, that they just didn't care much about whether they had to file this and didn't worry about it. And that most certainly is not the case at all. You have some extremely conscientious people who did everything they could to figure out how to timely file the correct reports. Within days of even forming at all, they had filed reports with the city to the best of their information and to the best of their ability, and they included all of the information that is being complained of on another report. So at the end of the day, the complaint seems to be the ones that I presume are still being actively pursued are that ATX1 reports should have been filed by a date certain. Not that the information wasn't provided, that the report should have. We submit that does not present any reasonable basis to believe that a violation has occurred. The ATX reports are not required by code. It is not clear from the guidance on the website how to even file one with the new electronic reporting systems. And so not having that information in that tight window, my clients did the best they could and submitted the information on a different report. The city code requires reports to be filed with the information. That was done. Again, we do not believe this presents anything. There are no issues at the hearing or at a hearing really to discuss. The facts are all out there. The information is there, and my clients and myself respectfully request this commission find there's no reasonable basis to proceed and dismiss these complaints. Thank you.
Thank you, Mr. O'Toole. So with that, commissioners, we are now able to ask questions of the respondent and complainant, but I think I'm going to do some sharing again and try to make our lives a little easier in narrowing the scope of our discussion. And here's what I'm ultimately proposing. So two of the complaints that Mr. Littlefield provided, they cite the section of charter or ordinance violated as 2-2-3. And that is the same section that is the kind of incorporation of state election law into the definitions, the terms that we use, or rather This is the part of the day where I start to fade fast and my words fail me. We've discussed it previously, and I believe we discussed it at some length in the November hearing, actually, when I explained to Mr. Littlefield why we dismissed a prior complaint against a prior respondent where the complaint alleged the same 2-2-3 violation. So what I'm ultimately proposing to do, since this was a complicated set of complaints that we combined into one hearing, it was not as easy or clean procedurally for me to make the jurisdictional determination as chair as is allowed under our rules. But in lieu of that, what I'm going to propose is that we find that there's a failure to allege a violation, and I'm going to quickly read what that means. So the disposition of a preliminary hearing, one of the options, so there's obviously the option of the existence of reasonable grounds. We would try to go to a final hearing. There's an uncontested violation. I'll get to that in a second. But there's also failure to allege the violation. If the ERC determines the complaint does not allege a violation of a provision within its jurisdiction, then before a complaint is dismissed for failure to allege a violation, the complainant or legal counsel for the ERC shall be permitted one opportunity within a period of time to be specified by the ERC to revise and resubmit the complaint. So that is, so if we were to vote, for example, like if someone were to make a motion, I move that that the complaints, I don't know if they have actually numerical designations like case numbers, but the complaints filed on this date, the ones that I hope you know I'm referring to, the ones that allege violations, that only allege violations of 2-2-3, that we find that those complaints, there's a failure to allege a violation, and then we would discuss maybe a period of time, I think typically like 30 days to amend or revise a complaint if a complainant decides to do that. So that's what I'm going to pitch. Commissioners, if you've got thoughts or questions to discuss, Vice Chair O'Hurry, go ahead.
I move to find that the complaint against Ms. Wood filed by Mr. Littlefield, alleging a violation of City of Austin Code 2-2-3 does in fact not allege a violation of any code.
Okay, so moved. Is there a second?
I second that. I have a question though.
Well, let me, I saw Secretary Gober's hand up first by a hair.
Go ahead.
So he's the second, but now discussion on the motion. Go ahead, Donna Beth.
My question is, they were having all of these problems and with the different farms, did somebody pick up the phone and call for clarification or help?
So,
That's a final hearing question.
well, yeah. So what I'm going to do is just kind of clarify where we are. We're going to get to the question and answer of complainant and respondent. What I'm proposing is that for the two complaints where I would have made a jurisdictional determination prior to the hearing, I'm pitching that this motion and what Vice Chair Hurry moved is that we say there's a failure to allege a violation, and this then, you know, I'm actually going to have a friendly amendment that we give the time window that's required by the rule for them to amend their complaint or revise or resubmit a complaint, because that's contemplated in city code as well. But just to clarify, we're going to be able to ask all the questions we want of complainant and respondents, but right now we're on a motion. So further discussion on the motion.
I didn't get my question in time, so go ahead.
No, we are gonna ask questions. I am
Okay.
It's not on the motion.
Scout's honor. We're making question and answer time happen. So if there's no other discussion on the motion, then I'm gonna offer a friendly amendment to the motion that we give the complainant 30 days to amend or resubmit the complaint that we're finding does not allege a violation. So
I would actually just say 10 days. And before we even address that, figure out if he wants to refile this. I mean, it's either he has a violation to allege or not. The code is pretty clear. I don't personally see the purpose of doing 30 days, 10 days, and then we just keep it moving.
sure, that's I mean, that's fair. I think we can kind of agree to disagree on how much time should be allotted for it. My thought is 30 days is going to take us through our next hearing. And if it is resubmitted, then we'll have another hearing to go before it comes before us again. And also that our next hearing might be a busy one potentially. So in 30 days, I don't know, I've not being someone who's litigated a lot, I don't know how much time you typically get to amend a complaint or a petition. Someone could correct me on that. So I I'm gonna restate my motion, which is an amendment to the motion, 30 days being the period that the complainant has to, if they want to, they don't have to, but if they want to, amend or resubmit their complaint on these two specific complaints, 2-2-3. So
I'll second it.
thank you, Commissioner Kale. So discussion on the motion to amend the motion. Okay, great. So all those in favor of amending the motion, I'm going to take hands and call out names this time, if that's okay. So if your camera is off, then thank you so much. I appreciate it. Okay, then I'm going to start calling out names. Once I get to the folks that aren't on the screen yet, I'm going to give you a shout out. Okay, so I see Commissioner Kale. Aye. Commissioner O'Hurry. See Commissioner Greenberg. Aye. Commissioner McCormick. Aye. Commissioner Danberg. Aye. Commissioner Ryan. Aye. Commissioner Villalobos. Aye. Commissioner Laurie. Aye. Commissioner Lerner. Aye. And Secretary Gober. Aye. I vote aye as well. Okay. Motion is amended. We're going to have another vote on the motion. This is to say that there is a failure to allege a violation for these two complaints, and the as amended part that the complainant has 30 days if they wish to amend or resubmit the complaint.
No, pardon me. This is Lynn Carter from the Water Department. Can you just make sure there are no votes on the motion to amend?
Fair enough. So on the motion to amend, does anyone vote no? Are there any no votes? I'm going to go once, twice, 3 times. Hearing no nays, I believe that was a unanimous passage for the motion. So then the question is now on the motion as amended, as I just described it. If it is okay with commissioners, I'm going to go by the same method of calling out names and hands as I see them, just so that we can move on to the more substantive, maybe contentious parts of this hearing. So I'm starting to call them out as I see them. I see Commissioner Danberg, Vice Chair O'Hurry, Commissioner Kale. Those are ayes, sorry. Let me clarify and I'm going to start over again. I'm calling out the ayes on the motion. So Commissioner Kale, aye. Vice Chair O'Hurry, aye. Commissioner Greenberg, aye. Commissioner Danberg, aye. Commissioner McCormick, aye. Commissioner Ryan, aye. Commissioner Laurie, aye. Commissioner Lerner, aye. Secretary Gober, aye. Commissioner Villalobos, aye. And I will call out the nays. Is anyone voting nay on the motion? Any abstentions on the motion? Hearing and seeing none, I think the motion passes unanimously. So, okay. So that takes care of that. We are now in a question and answer period, and I did have a couple of questions just to clarify the complaint that Mr. Littlefield is wanting to withdraw or shows that there's no issue on or mistakenly filed, just so I can feel confident in what next steps we might be taking as a commission. So, Mr. Littlefield, do you want to kind of explain that complaint, how it was filed, and what you want to see done with it now?
I'm sorry, can you repeat the question? I zoned out for a second. I apologize.
Nope, not a problem. I'm going kind of fast. So everyone is invited to slow me down at any point. So the complaint, you know what? I'm going to scratch that. I think we just took care of that complaint. Never mind. Okay, we are on to question and answer period. I'm going to withdraw even pretending to ask a question. Commissioners, any questions for the plaintiff and respondent? Vice Chair.
Okay, I just want to ask these 2 questions. First question is, we all agree that the complaint that was filed that references Fight for Austin is a complaint that should not have been filed. Is that correct, Mr. Littlefield?
That is correct. That is correct information.
Okay. And
I'm
then,
going to clarify that was a complaint that we just took care of in the motion we just passed, because it alleged a violation of 223.
okay, that is correct. All right, and then as well, Mr. Littlefield, you do agree that within the City of Austin Code, there is no specific mention of having to file a report of filing specifically an ATX1 report.
No, I don't agree with that.
Okay, I'll ask you this. Is there any phrase within the City of Austin Code that is ATX-1?
Yeah.
Okay, where is that?
Code section.
Oh. I got my code book. Two section. Oh, never mind. Hold on. Wrong section. 2-2-31. Isn't that it? I'm not looking at the actual code. I'm looking at my crib notes that I always use. So let me actually go to the actual code book, not my actual crib notes.
2-2-31.
Hold on, that might be right. I'm looking at my crib notes, not the actual section.
Okay. If someone else has some other questions, I'll open it up to them.
Okay, let me keep looking.
Secretary Gober, go for it.
It's in the same vein. This kind of gets to the same issue, Mr. Littlefield. The respondent has told us this is an issue of form over substance, and that all of the information that was required by code, regardless of whether code asked for ATX1, but all of the information required by code was provided. Can you tell us, is there any piece of information that should have been provided by code that wasn't provided in the form of the filing, even though it wasn't the ATX1 form? In other words, was there anything missing other than it not being in the form that
No, it was all.
But
No, it was all about timing. It wasn't about that the expenditures were missing. It was all about timing. The ATX1 report is not about information. It's about timing. That's what ATX1 reporting is about. It's about timing. That's why we require ATX1 reporting, is so that if you make a expenditure, that it is reported within either 48 hours or 72 hours or 24 hours.
Secretary Go, is that a follow-up question?
Yeah, so that's my question, I guess, then, is what was filed. It's not that the information provided was inadequate, it was that it was provided late, correct?
Correct.
Whether it would have been an ATX form or some other form, it's that the information was provided late.
Correct.
Okay.
Other questions?
Okay.
Okay.
Yeah.
Mr. Littlefield, and so this is just me just looking at the code itself. 2-2-32 does mention requirements regarding timeliness and when something has to be filed. Are you alleging any specific code? And right now I'm looking at 2-32-C. Are you alleging that there was a violation of any portion of that code? And if so, what specifically?
If I can rephrase the question, can you point us to the provision that requires the 24, 48 hours, 72 hour, the time limits that you described as reporting requirements?
Part C.
You're just under 2-2-32 because that's where the complaint alleges the violation.
Isn't it Part C?
I'm running slow now, of course.
I think it's Part C.
Two dash
2-2-32. C might be a natural place for it, but I don't see it there. You can point to another part.
Well, it does have time limits for when they have to be reported in Part C. No later than the second day, no later than 5 p.m. of the first business day after the expenditure, depending on when the expenditure was made relative to 60 days before the election or 9 days before the election. That's all in Part C.
Thank you.
Okay, then I think my kind of follow-up clarifying question is whether or not the ATX1 report that requires the time limit you described, Mr. Littlefield, whether the ATX1 report is supposed to be the form that comports with 2-2-32.
I don't see that in the code. I don't see that form listed in the code. I do see that form listed on the campaign finance forms, but not in the code.
Sure. So where I'm personally kind of struggling is that I don't think it's necessary for the city code to specifically say section 2-2-32, or sorry, the city code doesn't need to specifically say ATXN1. I think whatever the city clerk decides to name a form, as long as it is a form that comports with city code, that's all well and good. I'm trying to determine whether 2-2-32 is in fact the underlying code that the ATX1 form is meant to satisfy.
I think the answer is yes.
Okay, Commissioner Greenberg?
The allegation is that they should have filed the ATX1 report, which is not in the code. I think we should dismiss this. If the complainant wants to refile, they can complain that it wasn't filed, the information wasn't filed in a timely manner, if that's the allegation, but that's not what this complaint says. So I would move to dismiss this complaint.
I second that.
Okay, we have a motion and a second. Then we are now in discussion on the motion, commissioners. So, willing to entertain thoughts and comments on the motion itself. I'm seeing no, go ahead, Vice Chair.
I tend to agree with Commissioner Greenberg. The Texas election code, which is somewhat analogous to the City of Austin code, actually does specify the forms. This code doesn't. And so for that reason, I think the case should be dismissed.
Any further discussion, commissioners? Secretary Gober.
Just a point of clarification on what the motion is this, this isn't a dismissal on lack of jurisdiction where the complainant would have a time to remedy. This is a dismissal because based on the specific violation alleged, we don't believe that that's a violation. That's where I'm coming back to, it almost feels like it's a jurisdictional question.
Sure. No, it's a fair point to raise, and something that I'm grappling with myself is whether or not the appropriate route for us to take is a flat out dismissal because we do not believe reasonable grounds exist for a violation may have occurred. If
As was filed.
Sure, as it's filed, I think dismissal sort of depends, dismissal outright kind of depends on it's citing a correct piece of code, but that the sort of circumstances and facts as we understand them in the preliminary hearing don't lend themselves to believing that reasonable grounds exist that a violation occurred. So I kind of struggle there myself. Secretary Gober.
Just as part of discussion, I'm going to vote for the motion, but the reason I'm voting for the motion is as a matter of notice for the respondent. I think it was entirely fair for the respondent to come here today to be prepared to talk about the information that they had in what they filed versus what was required in an ATX form. I think that Mr. Littlefield has conceded that the issue isn't substance of what the different information was, but timing. And as I'm looking at the complaint, as I'm listening to the motion from Commissioner Greenberg, I don't see a complaint about timing of the filing. I see a complaint about substance of the filing. And I think that's already been conceded. So that for that reason, I would join the motion.
Okay. Further discussion, commissioners. Okay, seeing none, then I'm going to call a vote. This time I'm going to call names and ask for commissioners to unmute themselves and say aye as I call the ayes, and then I'll call the nays. So, as I have been doing, where did my agenda go? Here we go. Okay, so this is a vote on the motion to dismiss this complaint.
Can I clarify? There are two complaints
There are.
that allege the ATX1 report. At the 11th hour, I'd like to say dismiss both of them for the same reason.
Well, so
There's no code for the ATX1 report.
well, okay.
Otherwise, I'm not even clear for which one we're talking about.
Well, that's a great question, and that's a point of clarification that's worth
Since I made the motion, I
reading
should
out.
know.
So if you want, what I'm happy to do, Commissioner Greenberg and I think Commissioner Kale, since you seconded it, if you want to withdraw the motion and we can restate it with a little more clarity, we can do that as well. So, would you like to withdraw the motion?
Sure.
Sure.
Restate it.
Commissioner Kale, since you seconded it, okay, withdrawing the motion. Okay. You would like to restate the motion.
I move that we dismiss both of the allegations or whatever these called violations, alleged violations that state that they should have filed ATX1 report.
I second the motion.
Okay. Motion's been seconded. Discussion on the motion, commissioners.
It's been done that.
Okay. Seeing none, seeing no hands and takers, then I'm going to do what I said I was going to do before.
Mhm.
I'm going to start calling the ayes first, and then I'll go through the nays, and I'll go in the order as it appears on the agenda. Okay, so sorry, I have about 15 million tabs open right now. Here we go. Okay. All right. Chair Soberon, aye. Vice Chair O'Hurry.
Where did it go?
I see your hand up. I'm going to ask that commissioners say their vote aye as opposed to the other kind of procedural motions we were doing before. So Vice Chair O'Hurry, do you vote aye?
Aye.
Okay. Secretary Gober.
Aye.
Commissioner Danberg.
Aye.
Commissioner Greenberg.
Aye.
Commissioner Kale.
Aye.
Commissioner Laurie.
Aye.
Commissioner Lerner.
Aye.
Commissioner McCormick.
Aye.
Commissioner Ryan.
Aye.
Commissioner Villalobos.
I'm learning this whole new system. Anyways, nay.
Okay, Commissioner Villalobos voting nay.
Yes.
Got it. Okay, so what I had as the ayes, does anyone else vote nay? I'm going to just have a call for the nays. What I have as the ayes being 10, nays being 1. So the motion passes and those complaints are dismissed. Carter, you can also correct me if I did something procedurally off kilter, but I think with that, then you are dismissed. Ms. Glotzer, serving as our counsel, you're dismissed as well. Mr. O'Toole, thank you very much.
Don't we have one more?
We've got one more hearing with a different attorney and a different respondent, if that's what you're asking.
Oh,
I'm missing
that was the one. Okay, got it.
unless I'm missing a
No. I believe you're right.
That's correct.
Didn't.
Okay, got it. Commissioner Danberg, you got your hand up. What's up?
I just want to say that I very much appreciate Mr. Littlefield keeping us honest, and Ms. Davidson, and
She's gone.
whoever the other attorney who was recently defending.
Mr. O'Toole, I believe, yes.
Yeah, Mr. O'Toole. I want to thank y'all for keeping us legal.
Thank you. Am I excused?
Yes, you're excused, sir. Thank you so much.
Okay, thank you very much. Good night, everybody.
Good night. Okay.